just, I mean, the conduct is the provision of a platform by which to communicate with each other and other members of ISIS and by which to recruit. So you can, say it's the failure to better police the platform, but it's the provision of a platform.
The distinction that the cases make between action and inaction, and the plaintiffs in this case have repeatedly characterized the gravamen here as inaction, failure to do better to prevent more violations of an established policy. The distinction between...
Maybe that's right. I'm going to rewrite their complaint for them.
Okay.
It's the provision of a platform.
Okay. The distinction that all of the cases, the aiding and abetting cases, draw between action and inaction is culpability. And therefore, and what is alleged to be culpable in this case is not the provision to billions of users of a communications platform subject to established policies which are enforced. What's alleged to be culpable is that we knew from government reports and from newspaper reporting that there, notwithstanding whatever efforts we were making to enforce our policies, nonetheless, there were lots of terrorist organizations or terrorist adherents that were still doing it. That's the culpability, and that's why the restatement, for example, when it talks about, and I'm referring here to restatement third, the substantially assisting a wrongdoer means affirmatively helping with the commission of the tort. It does not mean, it means, quote, something more than routine professional services.
I feel guilty that you're not answering Justice Sotomayor's questions, but I'm just going to pile on a little bit, if you'll forgive me.
I think I have them in mind, and I will come back to them.
The same thing could have been said about banking. It was, we just provided the same banking services to the terrorists as we did to everybody else. But in fact, the provision of that service materially supported, and the bank knew that it was going to materially support terrorist operations.
So that may or may not be the case. The Second Circuit and the D.C. Circuit erred in, we think, notwithstanding the distinction that I'm having a hard time convincing you of, because they collapsed the mental state required under Step 2 and Step 3 of Halberstam. What they said is the pharmaceutical company was providing money and kickbacks to a known terrorist organization. It was generally aware that this was a terrorist organization. And that satisfies Step 3, which is the knowing provision of substantial assistance to an act of international terrorism. Likewise, the Second Circuit has said expressly that the only knowledge required to establish the requisite mental state for abetting a crime is general awareness of that you are aiding an enterprise. Now, the word enterprise, maybe I can shuffle back to or march back to Justice Sotomayor's question. You referred to the Halberstam's opinions discussion of the criminal enterprise and aiding and abetting the criminal enterprise. We are here, I have 3 points to make. One, we are here parsing the language of a statute. The word enterprise does not appear in the statute. The word that appears over and over and over again is the act of international terrorism that injured the plaintiff. Number two, the Congress in its findings said that it intended to import the legal framework set forth in a section of Halberstam conveniently called legal framework. Again, there is nothing in the legal framework set out there that talks about aiding and abetting or substantially assisting an enterprise. In any event, we don't in any way contest that the court, in applying the facts in Halberstam to the legal framework, referred over and over again to the substantial assistance that she was providing to the enterprise. Now, the word enterprise, if you look in the dictionary, has a variety of different meanings, but the two first meanings are, number one, it can refer to an entity that is typically a, quote, unit of economic organization, or quite distinctly, it can refer to an undertaking, systemic, purposeful activity. What Halberstam was using the term to do was to characterize the factual characterization of a series of property crimes in which it held that Bernard Welch and Linda Hamilton played, quote, symbiotic roles. It was not announcing a legal standard that encompasses a broad entity that provides general services to billions of people subject to an unequivocal enforced policy against terrorism. So even if I agree with you that you can establish substantial assistance to the principal tort by showing that there was a course of, a series of like acts of international terrorism or burglaries or property crimes in which the aider and abettor was, to quote the D.C. Circuit, a willing participant, and therefore aided and abetted the principal tort, which was the burglary of the Halberstam home. I don't have a problem with that.
Thank you, Mr. Waxman. Justice Thomas, anything further?